Dan Kraus. We'll start in just a minute. I am just making sure that everything works. So if you could, I'd appreciate if somebody puts in a little note in the chat to say whether they can hear me and whether they can see me. So if you're just adjusting your settings to see whether, oh, great. Thank you. Wonderful. All right. It is exactly 10 o'clock, so I want to get started right on the money. As people join, they can catch up, and there will be a recording of this session that will be put up on Facebook as well as our YouTube page. And we'll be having sessions like this every month in the future. In fact, a couple of times a month. The sessions and the presentation will not change very much, so don't feel like you have to attend this, but if you feel like you got something out of it and you wanted to get a little more out of it, you can attend as often as you like. Obviously, there is no charge for this. Thank you for responding. I appreciate you letting me know that I can be seen and heard. And so we will start. Okay, today we're going to talk about estate planning. I hope that's why everybody is here, is to talk and listen to me talk about estate planning. It's a little, it touches my ego a little bit to think that people would actually listen to me talk, but I have been doing this for about almost 25 years now, and so I know a thing or two about estate planning. So I thought I would start to spread the word and spread the knowledge out there, because I've found that estate planning is really important, and it's helped a lot of people that I've worked with to help their families. So my name is Dan Kraus. I'm an attorney. I am in Wisconsin, and hopefully most of you are also in Wisconsin, but I do practice a little bit in Illinois and Minnesota. I'm licensed in those 3 states, but my primary practice is in Wisconsin. A lot of this estate planning talk that we're going to have applies to every state, but some of it is specific to Wisconsin, and I'll try to tell you when it might apply to not only Wisconsin, but other states, or when it's only Wisconsin. Like I say, many of these principles are just general principles. So who am I? Whether on the screen, you can see a little bit about me. I'm very proud to be a former service member, retired member of the JAG Corps. I was a major when I retired in 2016. And the Army has done a lot for me. The military got me through my undergraduate education with the GI Bill, and it's actually paying for part of my daughter's education right now. So I'm very happy. The Army has done great things for me, and if you want to talk to me about that, we can talk offline. I wrote a book, Estate Planning in Wisconsin, and it is available, I believe, on Amazon. They ran out of stock recently, and I think we sent them another shipment, so hopefully it's back in stock, but there's a picture of the book there. Let's see. Oh, I'm also an estate planning law specialist. There's 7 of us in the state of Wisconsin who are authorized to call themselves specialists in estate planning law. Also very proud of that. And my Peace Corps experience just shows that, you know, the military and the Peace Corps is what we try. We try to have our team reflect the elements of service, the elements of compassion and love, integrity, and those good things in our service to our clients. This is our team. I'm on the upper left. My other attorney, Attorney Carly Fensky, who is great, and she's actually better at me than at this stuff than I am a lot of times. And we've got a couple of paralegals, legal assistants, executive assistants. Laura Hamden is the client care specialist. The whole team is great. And if you ever contact us, these are the people that you might talk to. As far as the firm, we have many memberships and affiliations, as well as many accolades. So this page just shows a few of those things that just show that we are focused on estate planning. We know what we're talking about, and we do have connections to the organizations that can help us out to help our clients. All right. So what we're going to talk about is the purpose of estate planning. Now, the title to the presentation is 4 things about estate planning. We're going to talk about 4 plus. We're going to talk about many things that have to do with estate planning. So the purpose, we're going to talk about a little bit of the history of estate planning, what you need to know about wills versus trusts. Some of you may have heard of revocable living trust, and those we're going to talk about as well. How to choose the right attorney, and then I'm going to encourage you to take action. Then we're going to have some time for question and answer. So let's see. Can people see the slides? The slides should be right underneath my picture. Okay. I had somebody say that they were unable to see the slides. So maybe if you scroll down, the slides should be larger than my picture on the screen. Okay, thanks for letting me know. Okay, and my Laura, our client care specialist, is also on the line right now. So if you've got questions, please type them in. She will take note of them, and then she'll feed them back to me at the end of the presentation, so I can try to address everything without interrupting the presentation. Okay, the purpose and goals of estate planning. The purpose of planning is to take charge of your life. And with estate planning, it's also taking charge of after death, so your legacy. So any planning is just really to get your hands around things. Some people say it's to put the ducks in a row, but really it's to have control. It's to gain control. Okay, what is your estate? Everyone has an estate. It's the things that they have, and sometimes it's their pets, it's their collections, sometimes it's works of art, sometimes it's money, oftentimes it's real estate. All of those things that you have and that you control are your estate, including now family, which you don't really control, but you do have that. That's part of your estate that you need to consider. Your values, passing on values along with your money is also another part of your estate. And your legacy, which is a concept of just how you want to be seen or perceived, or the effect that you want to have after your death. Goals of estate planning are many: to give what you have to who you want, when you want, and the way that you want, so that people don't just sometimes want somebody to get things the moment that they die. They want them to have to wait until they've grown up or until they've achieved a certain level of education or things like that before they're allowed to have their assets. And that kind of control is the control that we're talking about. To care for yourself during your lifetime, if you become incapacitated and unable to care for yourself, that's another goal of estate planning, to make sure that that's covered. To care for and protect people that you leave behind or that you're unable to care for if you become incapacitated, that's another goal of estate planning. You want to minimize or eliminate probate, which is a court case that we'll talk about a lot in a little bit. To fulfill your charitable intentions. Many times people can't afford to give during life, but they want to give after they're gone and they don't need their money anymore. Pass on values and ideals to your children and grandchildren. Maximize the assets distributed. So if you have so much of an estate, you want to get as much of that to the next generation or to your loved ones or your charities as you can, with skipping the tax man and skipping all the administrative costs, and skipping the dangers of the expenses of long-term care. And finally, you want to protect your assets from creditors for generations to come. So if your children have problems with, say, handling money or bankruptcy, or they've got a terrible spouse, you can do things with your estate planning to protect their inheritance for them and not for their creditors. All right, so I'm just going to leave this up on the screen for things for you to consider. There are many things that would really indicate that a person needs estate planning. Some of them are listed here, but the people who need estate planning the most, I would say, are people who are in, say, a second marriage situation where there's children that don't belong to both spouses, people who have charitable intent, because without estate planning, no charities are going to get any part of your estate. People who have others in their family that they want to make sure they don't get anything at all. That's disinheritance. Without an estate plan, you can't disinherit anyone. And it goes on and on. In order to accomplish the things that you need to accomplish during life and after death, you really need a plan. Otherwise, you're relying on the state law and the state rules. All right, so we want to talk about certain definitions. Probate. Probate is just a court case. Some people say it's a court case you file against yourself in favor of the people that you owe money to. Well, that's a fairly accurate description. A court case that you bring against yourself. That seems silly, but it's required by law unless you've done some planning that can avoid that. Probate is the part of the court system that handles the after-death administration. It also handles other things if someone becomes incapacitated. Probate courts handle guardianships as well. So guardianships, along with the after-death probate, are both types of probate that people want to avoid generally if they can. Taxes, we all know what taxes are, but with estate planning, we generally deal with estate taxes, which very few people need to worry about, and we'll talk about that a little bit later. Gift taxes, which is a tax when you give away a certain amount of property. Income taxes, property taxes, and inheritance taxes. One other tax that is not written down here, but we deal with a lot, is the tax that happens when your assets gain in value. It's capital gains tax. And that kind of tax can really affect somebody when they inherit property. If they don't do it properly, or if the person that gives it to them does not do it properly, capital gains tax can be a problem. And asset protection for your children from their spouses and their creditors. So we want to make sure that when we give assets, they're as protected as they can be. Otherwise, sometimes they're not all that useful to the people that you leave behind. Okay. So let's talk a little bit about the history of estate planning and where we are today. So estate planning is a fairly boring area of the law as far as most people are concerned. I get excited about it. In fact, I'm very excited that there's a new law in Wisconsin. Just a week ago, they passed a law that now allows us to remotely witness wills and trusts and powers of attorney. We couldn't do that before last week, but now we can do it through the camera, where everyone has to be in Wisconsin at the time, but they don't have to be in the same place. And this is all brand new. So we're learning about the new law. We're creating procedures, and we're going to be able to help people who are homebound that we couldn't help before. It's very exciting. But so the history of estate planning, say 50 years ago in the 1970s, nobody really knew about trust. Trust existed, but the will was the centerpiece of every estate plan, nearly every estate plan. And will-centered plans have to be probated. The will has to be brought into the probate court. The probate court has to look at it and ask if anybody has objections, etc. And at the time, in the 70s, the $600,000 estate tax exclusion was relatively low. If you had more than that, your estate would have an estate tax. So couples, if they had over 600,000, they had to be careful, and so they did some AB trust created in a will, which we don't really have to go in, but it would allow them to use 2 times their $600,000 estate tax exemption. And significant probate costs were the norm. So you just had to realize that a certain percentage of your estate was just going to disappear after you died because of the probate and the process that went through in order to get the assets to the ones that you love. There's been a shift in planning starting in the 1980s. It started a little bit before that, but it really started catching on in the 1980s. And up until now, it's really become the centerpiece of most estate planning, and that's the revocable living trust. Revocable living trust is a way to plan your estate for what's going to happen after you die without going through the probate process. It's been a revolution in the estate planning world. So not all attorneys have caught up with this trend either, and it's sometimes a complicated process to set up. So the attorney's got a job to do, and not every attorney is a specialist or somebody who works in this area all the time. So many of them are still doing wills for people when perhaps they should be doing trust. Sometimes people will do separate trusts for the spouses. In Wisconsin these days, we almost always do a joint trust. So we throw all the property into one trust, so it's held together for two spouses. But you can also have staged distributions with trusts. You can throw the money after you've passed away into a trust for your kids, and then they can get a certain amount at this age, and a certain amount at the next age, and a certain amount at the third age. You can have as many ages as you want, but it gets a little complicated if you start throwing in too many out there. So I give just a little example of that. And then another thing, since 50 years ago, we've had a lot of talk about the right to die. And the right to life is a big issue, but the right to die has been a big issue in the past, and it's not really much in the news anymore. But people who have been on a ventilator and they're unable to manage their own affairs because they can't talk, they can't speak, and maybe they're not conscious, and they believe that they're never going to be conscious again, a permanent coma or a persistent vegetative state. So when a person becomes a vegetable, now they can sign a document when they are healthy that allows them to say pull the plug, essentially. So we've all become familiar with the pull the plug type scenario, and that is another revolution that's really happened in the last 50 years in estate planning. So estate taxes. We're really not going to talk very much about this. On the slide, it says there's a permanent $5 million exemption. That was a 2010 $5 million. That's probably right now around 6 to 6.5 million that you can pass estate tax free. However, this year and next year, we're still under this temporary law that gives us even larger exemption. So the people that die this year and next year will have over 13 million that they can pass estate tax free. Now, even at the $6 million or $7 million mark, most people are not going to have to pay estate tax. Now, the ones that do have more than that, good for them, good for you if you're one of them, and you should have a little bit of extra planning to make sure that you can minimize the estate tax if you're going to go over that amount. The permanent estate tax rate, now we say permanent, it's just until Congress acts again. So it's said to be permanent because it's going to last forever unless Congress acts. But of course, Congress and the president can do whatever they want as long as they can agree. They could change that to a lower exemption or a higher exemption. And there's always debates about what it should be. But for now, in your mind, you should think that you can pass $6 to $7 million per person at the end of life without having any estate tax. If you live in Wisconsin, excuse me. So it does matter which state that you live in, because Illinois has an Illinois estate tax that kicks in at, I think, about $2 million that you would have to pay something to Illinois if your estate was over that. Other states have their own estate or inheritance taxes. We're not going to go into which states have what tax, but just beware. Different states are different ways. Wisconsin does not have its own estate tax, so we're only dealing with the federal in Wisconsin. And then another nice change to the law back in about 2010 was that they made a portable exemption. So they didn't used to be able to say the spouse's exemptions could be portable, but now they are. So if one spouse dies, the other spouse can use their exemption, and now you can pass twice as much at the second death. So that's also a nice addition to the estate planning scenarios that we didn't have in the past. So planning for the 99.67%, that's approximately how many people are not going to have to worry about the estate tax. So we're talking about less than 0.5% that have an estate tax issue. And for those people, estate tax planning is very important. And we also take care of that. But for the vast majority of people, avoiding estate tax is really not a motivation. It might be a motivation until they learn, oh, we really don't have to worry about it. Most people plan to keep their family business private. They want to keep family harmony so that people don't fight. They want to leave things in a way that's going to make it easy or easier for the people they leave behind when they have to clean up, everything. The bank accounts, the investment accounts, the real estate, the personal property, the burial, the taxes and everything. You want to tie it up so that it's easy for the people that you leave in charge when you're gone. Asset preservation, obviously, you want to get as much of your assets to the next generation as you can without paying the tax man and administrative fees and attorneys and all that. And then there's capital gains tax planning, the planning to make sure that your kids don't have to pay a lot of taxes on things that you give them because they've gained while you've had them before. All right, let's talk a little bit about wills and trusts. Wills and trusts are not the only part of estate plans. We also need to focus on powers of attorney, healthcare powers of attorney, and financial powers of attorney. And there's many other types of documents that are included in a comprehensive estate plan. But wills and trusts are what we call the centerpiece. So when is a will-based plan appropriate? One time in my career, I had a client tell me, and it was perfectly legitimate reason. He said, I don't want to trust because I don't trust anyone in my family to do this right. I need the court to supervise them. So that's what we did. We made sure that that person's estate was dealt with in a will. That will would be taken into probate court, and then they would have to follow all the rules of the probate court in order to make sure that everything got to where it was supposed to be. What's the risk of a will-based plan? So the risks are, during your life, a will doesn't do anything. So it doesn't provide for incapacity issues like a trust would. So if you become incapacitated, your will really doesn't have any effect. Wills after death have to go to probate court. You can't just take a will into the bank after somebody dies and say, look, the will says I get it. The bank is not going to deal with you. You have to go into the probate court where they have rules of how you go about getting the bank accounts after somebody dies. They have to make sure that all the debts are paid. Your business then becomes a public record. As soon as that will gets brought to court, they open up a case, and now you have to report to the court the inventory. So what did the person who died, what do they own? Who's going to get everything? How much do they get? How much are they paying for the attorney? How much are the taxes? All of this has to be reported to the court, and it's a public record. People just can go into the courthouse and ask about the strangers' estates, and they can go in and they can look at those files and see how much you had. Your neighbors might be nosy like that. So that's a privacy concern. Before long, it's going to be out there on the internet. It's just public. There's nothing against sharing anything that's filed with the court in a probate case. All your heirs must be invited to the process, and this is what really triggers some people to get a trust because they want to leave somebody out. Some families have estranged children. So if a child hasn't been in touch with the parent for 50 years, let's say, the parent just wants to exclude them. But they don't want them to be invited to come in and object in a probate case. They would rather have it done privately where nobody has the opportunity to object. So you don't have to invite those heirs, which you would rather not be involved. You don't have to invite them to the process. Also, with the will, and only with the will, it's very important that the original is found. Or when somebody dies, if you don't have the original will, you don't have a will. Therefore, it's more risky to plan with a will than it is with the trust, because with the trust, any copy of the trust will do. With the will, you must have the original with the ink signatures and everything. So some facts about probate. Probate is a public process, which we talked about. It's complex. There's dozens of different forms that have to be completed and filled out correctly and filed with the court. Can be a long process. Average probates are over a year. And I've seen them go more than 10 years. It's a little crazy, but sometimes the people start fighting and they can't find the assets, and all these things can go wrong. I've seen it where a person who's in charge of a probate works on it for a couple of years and then dies, and now we got to find another person to take over the probate, and it's another couple of years before they get a handle on it. And obviously they can be expensive. If you need to hire an attorney to do the probate, which we do, we charge by the hour. We get it done as fast as we can, but we have to go by the rules, so it is expensive. So just as an example, this is not, probates don't go according to a percentage. In Wisconsin, in some other states, a probate you have to pay for by a percentage. But in Wisconsin, the court does take a percentage of the assets off the top. The court takes $2 per thousand. It's kind of a small tax, but it can add up. If you don't have to go through probate, you don't have to pay that tax. But what you do pay is all of the fees and all of the costs for the attorney to go through the probate. And let's just say it takes about $15,000 to get not so complicated case through the probate court. Well, if you start with $300,000 and you don't have any debt, that's about 5% of your estate that's shaved off in order to do the administration that it takes to get assets from you after you've passed away to the people that you want to get it. Now, that percentage can go up without the cost going up. As you can see, if you've got mortgages or other debts, the actual value of your estate might only be $50,000, but the probate cost is going to be the same, or might even be more. So it's going to shoot up the percentage of your estate that needs to go, that needs to be paid out in order to administer what has to happen after you passed away. All right, guardianship. So this is the other type of probate. This is the living probate, the probate while you're alive. If you become incapacitated and you have not done proper estate planning, meaning powers of attorney for healthcare and finance, if you don't have those documents, you would end up probably in guardianship court, where if you have disability or mental incapacity and you're unable to make decisions for yourself, somebody needs to make those decisions for you. So what does the court do? It takes away your rights. It takes away your ability to contract. It takes away your ability to promise anything. It takes away your ability to write a check or to use money at all, because you can't contract. So you're not able to agree to pay anything for something else, because that's a contract. That's a very simple handshake type of contract. You won't be able to drive or get a fishing license or a hunting license or any of those. Even voting is taken away from you, and all of those things, except for voting, nobody can vote for you, are given to someone else. So your guardian is given the ability to make decisions about your health care, your finances, where you're going to live, who can visit you, etc. And they're going to be able to spend your money on what they think is proper for you. So the court chooses your guardian or conservator. It's usually a family member if the family member steps forward and wants to do it. But sometimes no family member is is either willing or able, and then they will get a third party that you don't even know to become your guardian. So we want to avoid this if at all possible. Also, you have to pay the costs of this whenever it might happen. So you don't want to have to go through guardianship, especially when you can avoid it fairly easy. Now let's talk about ways to avoid probate that are not trusts. So you can put your property in joint tenancy. So the best example of this is a piece of real estate. Normally, married couples have their real estate in joint tenancy. They just put both married couples' names, both names on the deed, and now it's considered to be joint tenants. Oh, excuse me, phone's going on. I apologize. To turn that off. Okay, where was I? Oh yes, joint tenancy. So when one person dies of a joint tenancy, the property just goes to the other person. That's pretty simple. You don't have to go through the probate court. You really just have to file one piece of paper in the Register of Probate's office, or a couple of pieces of paper, and there's no problems. However, it's not always the greatest way to plan for what's going to happen after your death. So if you've got a married couple, one person dies, all the property just now belongs to another person if it's in joint tenancy. However, when the other person dies, now you got a probate, unless the other person also then puts it in a joint tenancy. The danger is they're going to put that property into joint tenancy with a new spouse. So after they're widowed, they marry again, and now they die, and the property goes to this other spouse. Now you got problems because your kids get nothing at all. So with joint tenancy, or joint tenancy with rights of survivorship, the last person alive owns all the property. Not always a great way to plan. Also, but it is not subject to probate proceedings. Joint tenancy can create unintended heirs. Like I say, the next spouse, the spouse that marries the widow. It does not totally avoid probate, because if you don't have a joint tenancy, when the second partner dies, you still have a probate. Also, if you're joint owner, let's say you put in a property jointly with your child. God forbid your child dies before you do, and now you don't have any plan at all for that property and it goes into probate. You also have capital gains problems. So let's just say that you decide that you want to put your house in joint tenancy with your child. It will go to them on your death, but if they then sell it, as long as they survive, if they then sell it, they're going to have to pay capital gains tax on that property, because part of it belonged to them before you died. So they're going to have to pay capital gains on that, on the gains since when you bought it to at the time that they sell it. So that could be very significant, especially if you had bought the house or the property long ago and it's worth double or triple what you paid for it. Now you're going to have a lot of capital gains tax for your kids if you pass it on with a joint tenancy. Other ways to pass things: beneficiary designations. So your 401k or your IRA or your life insurance, they should have beneficiaries designated on them, so that it says, upon my death, this is who I want to get things. And if they don't survive me, then here's the alternate. Here's who I want to get them as an alternate. You should have all of those things done. If you do, those things will also avoid probate. However, they might not be the best way to transfer these assets, because there's no protection, and really no way to say, well, what if both of those people pass away? Can you get a third choice and a fourth choice? Or what if one passes away? Do you want some to go to their spouse and some to go to their kids? This is not available on these forms to create beneficiary designations. You can't do anything very complicated. In fact, if it gets past the very simple, you really can't do it with the beneficiary designation with life insurance and 401ks, etc. So beneficiary designation risk, it doesn't protect your spouse from creditors, predators, etc. It does not protect or care for minor children, so that if you designate a minor child, a grandchild, uh, as a beneficiary on your life insurance, they will get the property once they're 18, and they can be tricked out of it, or they can just buy the things that 18-year-olds buy when they get a bunch of money and don't know what to do with it. It can cause unfortunate results. If it goes to a person who has, let's say, a disability or maybe a drug problem, it can, if they have a drug problem, a lot of money all of a sudden can kill somebody. With a disability, it's not as bad, but it can knock them off of the public benefits that they've been on. And it could make their life actually more difficult if you give them some money. So choose a trust instead of a will, or instead of beneficiary designations. If you want to make sure that somebody is going to be able to manage those assets during your lifetime, if you become incapacitated, you want to keep control over the plan during your lifetime, so you can change everything, can change it as you want to. Another thing about putting your house in your child's name or jointly with your child, you can't change it then when you want to. You couldn't sell the house without their permission. And you want to outline what's going to happen in the event of your disability. All right, so there's different types to transfer without probate, different ways. One of them is joint tenancy, which we talked about. Another one is POD or TOD. That is pay on death or transfer on death. Excuse me, and that's where you put a beneficiary on your bank account, or that's called a POD. Or if you put a beneficiary, let's say, on your investment account, that's considered a TOD. In fact, you can even do TOD deeds to your real estate. There's problems with that, and you can see there's different things that could go wrong or could go right. And the only one of these that makes everything go right and you can control everything is the living trust. Other problems that you have are you've got the probate, you've got a problem with what if they die before you do, if you've got a joint owner or a POD or TOD. What if you want to sell the assets? You're going to have a problem if you have a joint owner. You're going to have a problem sometimes if you bring in another owner, or you just give away the property during your lifetime as a hope that you're going to be able to still live in the house during your lifetime, etc. Are you protected from others' debts if they're a joint owner? No, you're not protected. All right. So you can also choose a trust when you want to control your distributions to your descendants. You can decide whether they get a special needs trust. Let's say if they're a special needs person. You can decide whether they get it when they're 18, which is usually not a great idea, or 21 or 25 or 26, or you can say 19 and a half if that's what your thing is. But it's your choice. That's the key. It's your choice, and you can spread it out if you'd like to. You can also give your beneficiaries trust of their own. So your trust during your lifetime after you die, you can split it up. Let's say you've got 2 kids, now it becomes 2 trusts, and they get a trust. It's not if they do it right after you die and they get divorced later on, they would not have to split this trust that you gave them with their ex-spouse. And if they go bankrupt or someone sues them, they can't lose what you've given them if you've given it to them in this special kind of domestic asset protection trust. You can create provisions for your spouse. If you've got, say, if you and your spouse have different amounts of money, you consider some of your stuff to be yours and your spouse considers some of their stuff to be theirs, and you've got a prenup, you can provide for your spouse during their lifetime without actually giving them the ability to give it away. So like in a second marriage situation, if you just say everything goes to my spouse on my death, you may have problems, or your kids may have problems that they never get anything because now your spouse's kids get everything, your kids get nothing. That can be a problem. Um, Minor children, minor grandchildren, even great grandchildren, you can make provisions for them, etc. We like to see people keeping control even after death. Now, some people have desire and enough money to keep control of assets even for generations after death. Usually, I consider the second generation is far enough because we don't know what the world's going to be like in 3 or 4 generations. But you could put the cabin in the woods into a trust, fund that trust with that cabin in the woods, and put another 100, 200,000 in there, and then that can live there and stay there and just be managed by the people that you leave behind. Okay, so you can also incorporate your personal values by charitable giving. You can also write in things explaining to your children or your grandchildren why you're doing certain things that you're doing, where beneficiary designation obviously does not allow you to do that. You can do pet planning, gun trust, etc. All right, you can save money in the long term with the trust because you don't have to pay for probate. Your kids don't have to go through probate. They don't have to get an attorney to charge them hourly to help them do all the probate things that need to be done, and the forms and the reporting and the waiting periods. And you can save estate and income taxes by using the available deductions and exemptions if you properly plan with trust. You can protect also, this is a different kind of trust. It's not the revocable living trust, but a lot of people, it used to be, let me back up. It used to be that people's main concern when they died was the estate tax, because the estate tax was over 50% and you only got a $600,000 exemption. So if you had anything over $600,000, whether it's life insurance that's subject to estate tax, whether it's 401k, IRAs, or real estate, if you add it all together and it was over 600,000, everything over that would get taxed at about 55%. It's a high tax. We don't have that high of a tax now. It's 40%, but still, that's enough. If you've got over $5, $6, $7 million, that's going to be taxed at that rate. But the people that don't have that kind of money, what's their concern? Their concern is not with the estate tax. Their concern is that nursing costs or assisted living costs is going to wipe them out. And it happens every day. Hundreds of times a day, people run out of money at the end of life, even though they saved, even though they had their house paid off, even though they had help. They run out of assets, and now they are unable to leave anything to their heirs. So what we can do is we can take their assets when they're healthy, stick them in an irrevocable trust that we call an MAPT, a Medicaid Asset Protection Trust, and then hand over control to the kids. Now, the kids now have control of those assets, but you can still use them as long as you get along with your kids and your kids are acting as the trustee. Now, those assets will be available to you during your lifetime as long as your kids cooperate. And at your death, it goes to the kids with a step up in basis, so there's no capital gains tax worries, and there's no need to pay nursing costs with those assets. That's another thing you can do with trust. So you can also plan for income taxes, estate taxes using trusts, sometimes irrevocable, sometimes revocable trust. Sometimes bypass trusts are used to split an estate at one death. Let's say if you have mostly a lot of assets where your spouse may only need half of the assets to survive on after you're gone, and you can give the other half to your kids right away. That can protect assets from going all to your spouse's kids after both of you die. That's especially if your spouse has different kids than you have. All right, so asset protection and income tax planning. Sometimes people create an IRA trust or a retirement plan trust in order to protect the retirement plan from uh, being taken or from being used improperly by their beneficiaries. So an IRA generally goes according to a beneficiary designation. It just goes straight to the person, and then they can roll it over into an inherited IRA, and then they have to take it out within 10 years to pay all the taxes. Sometimes people say, well, my child, if they get this $300,000 IRA, they will just blow it, or their spouse will steal it, or something bad will happen. So what we want to do is we want to take that IRA and point it to a trust. Now the IRA goes into that trust, and the trust pays out to the child maybe an allowance instead of just a big lump sum, and that can protect that child. You can use irrevocable trusts as well. We talked about the Medicaid Asset Protection Trust. There's also life insurance trusts that can take the life insurance out of your estate so it's not taxable. It can also give liquidity to an estate that might have just a farm in it that you're worried about paying the estate taxes, so you need some cash in your estate. You use these life insurance trusts. There's also domestic asset protection trust. Like I said, you can give to your kids that protects their assets after you die so that they can't lose it in their divorce or they can't lose it in a lawsuit. And charitable trust. You can set up trusts during your lifetime that don't pay to the charity until your death, but you get a lifetime charitable deduction that you can deduct off of your income taxes. So if you want to do some estate planning, which I hope you do, unless you've done some really good estate planning, you want to find the right firm to work with. So how do you do that? Well, here's some things to look for. Is the primary purpose of the firm doing estate planning and estate administration? Does the firm do divorces? Maybe they're not so focused on your estate plan. Does the firm do bankruptcy? Do they do other areas of the law, corporate mergers and acquisitions? Is the attorney or the law firm focused on this area of the law? Do they have expertise and experience? Does the firm practice collaborative-based planning? Do they invite you to bring your financial advisor into the conversation, or your CPA, or your insurance broker? Does the firm charge a flat fee or an hourly rate for providing estate planning and other services? Many people like a flat fee, like we charge. We tell them up front exactly what it's going to cost. They know that it's not going to be weekly or monthly. They get a bill, and then when it's finally done, they finally know what it's going to cost. Flat fee. Many people like that. Do they have a process in place to keep on track your plan? So, like, we have a client care program that's a subscription-based plan that if people are serious about their estate planning, they can subscribe to that, and then we will review that with them yearly, or as often as yearly, more often if they like, but yearly is included in the plan, and we will include some revisions to the plan also in that client care program, as well as educational events and other perks. And then it's a personal thing. Everything is emotional. Do you connect with this firm? Do you trust the firm? Do you believe what the people say who are working for the firm? And can you see yourself working closely with this firm? Because it may be a lifetime relationship, and in fact, it may even pass on to your kids to have the relationship with that firm once you pass away. And will this firm be around in the future? Just like I said, after you've passed away, if you've got a plan, your plan has to be effectuated by the people that you leave behind. And sometimes they reach out to a law firm to help them. So a comprehensive plan is not just a will or a trust. So what we consider to be a comprehensive plan starts with a trust, has a will in it, because no comprehensive estate plan, at least in Wisconsin, should be without a will. just in case, a healthcare power of attorney, a durable power of attorney, and that's a financial, a living will. So in case you are on life support and you want to be taken off at some point, you'll need to have a living will in order for your beneficiaries to allow you to die naturally. HIPAA releases in case people need to help manage your medical care so that they can access your medical information. Personal property memorandum, which would help get your personal property, like all of your sports memorabilia and your artwork and your furniture, into your trust. Memorial instructions, so what's to happen to your body, how would you want to be buried or cremated, etc. You can write all that down, and it's part of your estate plan. And then with the trust, you should always have a certification of trust or a certificate of trust and a trust ID card so that you can get assets into your trust when you need to. So just beware of do-it-yourself stuff or trusts from a firm that doesn't really specialize in this. You may get a trust, it may be able to own assets, it may be legal, but it might not do what you want it to do. So just be careful about do-it-yourself or plug in the name type trust documents. A firm should be using, they don't, when we do a trust, we don't start at the typewriter and just start typing. This is my trust. Of course, we use forms. The forms that we use and the forms that you should be looking for in a firm are comprehensive, attorney reviewed, often, and updated forms. So we use a forms library called Wealth Docs, and it's the Cadillac of estate planning software. It costs us about $1,000 a month just to be a member, but then we've got access to the community of very serious estate planners that are involved in this, and they all use the same type of forms, and then we customize the forms to what our clients' needs are. Also, properly funding your trust. It's very important. You need instructions to do that. You need help if you want it. So a good firm can help you make sure that all of your assets get aligned with your estate plan, and that's trust funding. So our estate planning process includes an initial client meeting where you decide, is this firm for me? Is this something that I need? Is this something that I want? And at that point, we would talk about whether you want to engage us as your attorney. Then you go to the design meeting. A couple weeks later, after taking a look at some questions that we want you to look at, you sit down with the attorney and you discuss your options and you solidify your wishes, and they're all taken down in notes on a tablet so that the attorney knows just how to draft your documents. Then 3 weeks or 4 weeks later, we have a signing meeting. All your documents are laid out and they're ready for you to sign. You review them to make sure they are doing exactly what you want. And then you implement the plan. After the signing, you start doing the asset alignment, getting your bank accounts, your real estate, etc., into your trust. And then you monitor and update the plan through the client care program. And this is an optional part of the plan, but the client care program gives you a partner to allow us to help make sure your plan doesn't go out of date. If somebody passes away, if your finances change, if you move, if you get married, if you get divorced, these things you may need help with later on down the road. So now the thing is, you need to take action. If you haven't done an estate plan, and you don't have to do it with us, you should do it though. It really needs to be done if you're an adult. So take action. The most common thing that I hear from people, and I ask everyone that comes into one of our discovery meetings, we call them the goals and strategies session. Sit down with people and I ask them, why are you doing this now? And almost always they say, well, because we didn't do it for the last 15 years when we knew that we should. We're finally getting off of the the wagon. We're starting to do this that we should have done. I want to encourage you to use this today, this seminar, as the booster to say, okay, now it's time to stop procrastinating. We need to take action. And as soon as you take action, you're going to start feeling better. But people run into excuses. We can talk about a lot of excuses, and there's thousands of them, more than I list here. But these are some excuses that people use. It costs money. Yes, it does cost money. It's not the least expensive thing that you're going to buy this year, I'm sure, if you buy an estate plan. But it lasts, and it needs to be done. It takes time. Yes, it does. It takes time, but it's worthwhile. Your kids, your loved ones will thank you when it all comes down, when the rubber meets the road. They will be very glad that you've done that. Some people think estate planning is a luxury, not a necessity. Well, when you're dealing with somebody's estate that has not planned, it becomes a necessity for that person. I have people come into my office and they say, my father did not have a plan and it was a huge mess and things went very badly, so I don't want that to happen. To them, it's a necessity when they realize what a mess it is when they don't plan. Some people don't want to think about it. They don't want to think about becoming incapacitated or dead. I understand that. But the thing is, it's not going to stop you from dying or becoming incapacitated. The bad luck of saying that, oh, if I do a will or a trust, I'm going to die right away. Don't worry about that. The real mojo is when you take the umbrella, it's not going to rain. So when you do an estate plan, the bad things won't happen. That's the mojo I like to think about. People think, especially young people, that they're never going to die and they're never going to become incapacitated. They don't realize that it happens to people until someone that they love dies unexpectedly. I don't have enough property to do estate planning. As we talked about, also guardianships can happen. So even if you don't have property, you don't want to go through the guardianship process. Estate planning is important for every adult, especially the young people, to do powers of attorney so that somebody can manage their health care and the other things, the financial things, in case they become incapacitated. You don't like attorneys? I don't like attorneys most of the time either. You can get over that. Just pick the right one. They will not hurt you. I promise. And some people just say, I'm going to do it myself. Yes, you can do it yourself. There are tons of places out there where you can download forms, you can pay for forms, you can fill out yourself. But unless you've gone to law school, unless you've done this for years, you're not going to spot the necessary things that are going to be needed for you and your situation. And you might make a mess. In fact, I make a lot of money cleaning up messes that people have made for themselves through the probate courts. No planning in place, so your business or your affairs are going to become public knowledge. Your surviving spouse might be fighting with your children unless you have the same children. God bless you if you're in one of those marriages, but many people are in second or third marriages. You really need to do estate planning if you're in that situation. Special needs children. If you have special needs children or grandchildren, estate planning is very, very important so that those children can be given the resources that they need without taking away state resources that may be paying for things that they need. You don't really want a court-appointed administrator, somebody that you haven't chosen, and you don't want the court to choose guardians for your kids. You want to be able to do that yourself if you have young kids. When should you plan? You should plan if you have a child, children reaching the age of majority. If you trust them to start making your decisions for you, if you become incapacitated, go ahead and do a plan. Name them as the agents, your trustees, your executors. When grandchildren are born, if you want to start providing for their education, for their futures. If you're nearing retirement, you're starting to see the financial future for yourself as you retire, you should do estate planning. Marriage, divorce, if your home is paid for, it's time to start saving that from nursing costs. If you have multiple pieces of property, especially if they're out of state, you should really do a trust-based plan so you don't throw your kids into probate in more than one state. Okay. More things about when you should plan. Essentially, you should plan as soon as you become an adult. If you've got kids and you haven't gotten an estate plan, please, please do an estate plan. It's going to help them when and if something happens to you. Should you review your estate plan? Yes, you should. We say probably every 3 years is fairly safe unless something big is happening, like health changes or people are dying, etc. Then you should review it more often. All right. So estate planning has come a long ways in the last 50 years. We've talked about an effective way of making sure that your wishes are taken care of. Estate planning, including a living trust, is a great way to make sure that your family is on the right track after you've passed away. And selecting the right attorney makes a difference. All right. Decide to act and not react. Instead of waiting for things to happen, plan for them, and then they will happen as you want them to happen. At this point, I want to see, Laura, can you feed me any questions? I'm going to start answering Vicky's question because I see it's at the bottom of the page. And Laura, if you can put questions in the chat towards the bottom, and then I will try to answer. So Vicky asked, did I understand correctly, TOD property, the kids would have to pay capital gains based on the purchase price that you paid? That's not correct. With the TOD property, the kids will get a step up in basis. So they will have to pay capital gains according to the date of death value. So whenever you pass away, the kids get the step up in basis to the date of death value. So the downside of the TOD is that if your kids pass before you do, if you're in the same car or the same airplane, it's not effective to transfer. Also, with the TOD deed or the TOD property, you're not saving it from nursing costs at all. All right. So we've got the handouts. People were able to find them. Best way to get a hold of my book. Look on Amazon. If it's not available on Amazon yet, we did ship another shipment out to Amazon. Just look for the book. Just put my name in, Kraus, and then put estate planning in Wisconsin. Should come right up. I think it's $15. Let's see. If the decedent and the inheritor live in different states, which state tax rules apply? It's the tax rules that apply in the state, number one, where the person resided at their death, and number two, where there is property existing. So if you have property in Utah and Wisconsin, let's say, and there's an estate tax in Utah, you may have to pay some estate tax because even though the person lived in Wisconsin, the property existed in Utah, so there could be an estate tax in Utah on that property. Some states have an inheritance tax. Now, inheritance tax is different than an estate tax. An estate tax takes the whole estate, says how much is it, and then puts a dollar amount on how much tax you owe. An inheritance tax is paid by the person that receives the property. So that's interesting. If the person who's giving the property lives in Wisconsin and the person inheriting the property lives in Massachusetts, let's say, if they have an inheritance tax, then the person receiving the property may have to pay an inheritance tax because Wisconsin does not have one of those. I'm not sure how it works, so I can't give you the details on it. But the inheritance tax is paid according to who receives it. The estate tax, which is more common, is paid according to the entire estate. If my assets have beneficiaries and POD, TODs, including real estate properties, does this approach avoid probate? Possibly. Like I said, I gave a chart that says sometimes it might avoid probate, although it might not, depending on whether the person that you named as a POD or TOD beneficiary survives, whether they have children, what relationship they are to you. It's going to go according to state law if that person doesn't survive. The problem with POD and TOD is that you can't put a POD and TOD on your personal property. So your tractors, your artwork, your gold bars, etc., those have to go according to a will or a trust. So yeah, you may avoid probate on some things. Another problem that I see, and this is more common with the POD, TOD method, where people are, somebody gave them the idea, you can put POD or TOD on everything, and then it's like you can do it all yourself. You don't have to pay anybody to help you, which is a great way to think about that, is to do it as simple as you can. But the problem that I see most often is all the assets or all the valuable assets disappear out of the estate. The bank accounts are gone. The investment accounts are gone because they had POD or TOD. And now somebody's left holding the bag and has to pay for a funeral. They have to try to sell the house without any cash to fix up the house or to pay the utilities until the house sells or to do anything, especially if you got more than one person involved. Like if you have 3 kids, there's always going to be one that says, I'm not chipping in for anything. You didn't pick the flowers that I wanted for the funeral, therefore I'm not going to kick in anything for the funeral. So if you got POD and TOD accounts, you've got nobody in charge of money to pay your bills and make sure that everything goes smoothly after your death. Please don't do that. What's the fee? Oh, that's a great question. What is the fee? It depends on the type of estate plan you need, and it depends on whether you're single or a couple planning. And it also depends on, the type of protection that you want to choose for your loved ones. But estate plans that we do start out at around $2,600-$2,700, and that's a will-based plan for a single person. And they can go up to upwards of $10,000-$12,000, even more than that, depending on the type of protection you need and whether you need estate tax planning and other things besides a revocable trust. If you're adding on irrevocable trust, family limited partnerships in order to reduce the value of your estate for estate tax purposes, we're talking about quite a bit more than that. So thank you for that question. All right, is an Illinois POA valid if the party has moved to Wisconsin? Yes, it is. It's going to be interpreted slightly differently, so I can't tell you if it's going to work the same as it worked in Illinois, but Wisconsin has a law that says all the POAs that are done everywhere, as long as they're valid in that other jurisdiction, they're valid in Wisconsin. Healthcare powers of attorney, though, they may be valid, but it's a crapshoot as to whether or not your clinic or your doctors are going to be able to understand them if they're not on the Wisconsin form. If people get used to seeing the same form, and then if they don't see that, they have to send it to the attorneys for interpretation, and it could be a life and death type of a question. What does it cost to manage a trust? So the cost to manage a trust, if it's a revocable living trust, is typically nothing. You don't really have to manage it. Once everything is set up, your bank accounts are in the trust, your house is in the trust, your and investments are in the trust, and all the beneficiaries are designated properly, you just go about your life as you always have. It really doesn't cost anything. You don't have any extra tax returns, etc. If you want someone else to manage a trust for you, so let's say you give, after you're dead, you give your kids a trust. So each of them has a trust while they're growing up. Let's say they're 15. It costs about 1% per year for someone else to manage that trust for them. So they would manage the trust. They would give them money for food, clothing, shelter, and education, things like that, healthcare. And then they would take a percentage for themselves or a certain trustee fee. So if you're managing your own trust, it doesn't really cost anything. If you're managing a trust for someone else, you get about 1% per year. If you're winding up somebody's estate, generally the trustee or the personal representative gets 2% off the top. Is an Illinois POA, okay, we did that one. Let's see. Is 90 too old to set up these items? My mother has a will, but that's all. No, it's never too late as long as you have competence. That's the key. If you have competence to sign things, which does not mean you have to be a rocket scientist and that you're really on the ball all the time, every time. All it means is if it's a low standard, you have to know who your family is and you have to know what you own. As long as you know those two things, you can do this type of planning. All right, so we talked about the cost. So trust, the average cost for a trust is right around probably $6,000. Like I say, it can be less, it can be more, depends. Our attorney said we didn't need a trust. We have one adult child, moderate asset value. Your information seems to disagree with that. Yes, I disagree with a lot of attorneys, especially ones who don't really do estate planning for a living. But, you know, different people have different opinions. We tend to do a lot of after death administration. We see what works, we see what doesn't work, and it doesn't cost you anything to have somebody talk to you about your situation. So, one adult child with moderate asset value. I don't know, are there any grandkids? Some questions that I would have for you are what types of assets are there? What are your goals for your child? Would you want them to go through the probate process? Would you want to set up something so that if you need nursing care, they wouldn't have to sell your house to pay for it? Those are all good questions that you might want to consider a trust. If I develop a trust in Wisconsin and then relocate to another state, do I have to do this process all over again? Typically, you'll want to at least have your trust reviewed and perhaps amended so that it fits with that state's laws. Sometimes it's a simple amendment. Sometimes it's redoing everything. That is a downside. I mean, you can always roll the dice and say, well, I'm only going to do planning when I'm just about to die and I know where I'm going to live. But that doesn't make sense because there's car accidents, there's sudden illnesses, there's all kinds of things that can happen. So I would encourage you, even if you're planning to move or you think you might move, still you should do some estate planning just in case. And like I say, any trust that's done in Wisconsin is valid in every other state, just like trusts that are done in any other state are valid in Wisconsin. So if you do move and you don't change your trust, it's still valid in that state. As to whether it's going to do exactly what it would do in Wisconsin, that's another question. It'll be close, but it's going to probably be somewhat different. If we don't subscribe to the client care program, is an extra fee each time we want to make any changes? Yes, there is a fee every time you want to make a change, except if you want to do it in the first 90 days. We give a 90-day grace period where you can change your mind or just say, hey, I want to flip these around. I want my son to be the agent instead of my daughter, or I want them to be co-agents instead of one and then the other. We can make any of those changes within the first 90 days of receiving your trust binder without charge. We don't charge you for making those changes, but after 90 days, if you if your situation changes or your desires change, then yes, we would quote you a flat fee and make those changes for you at that time. If you have a trust, why do you still need a will? That's a good question. Um, the will is with the trust. The will that's combined with the trust is called a pour over will. And the reason it's called that is because if anything is outside the trust at your death and the will needs to be probated for that asset, then the will just pours it over into the trust. That's really the main purpose of the will, is just to get the assets into the trust. So your will that goes with the trust package doesn't say 1/3 to this child, 1/3 to that child, and 1/3 to the other child. The will just says goes to the trust. That way it keeps it all private. Nobody knows who gets what except for this private trust is going to get everything. So we always do wills with trust. Usually they're never used, but on the odd occasion we do still have to probate the will. And just a quick story, one time we had to probate a will when our single male client died in his 60s, so he died fairly early. His father had died just 4 months before he died. Now the father was leaving the son some real estate, and the real estate had not gone through the process of transferring to the son before the son died. So we had to open up a probate with the pour over will. We accepted the father's gift to the son, and then we transferred it into the trust. So that's why you have a pour over will, because you don't know what might need to go through probate in the end if it does have to. All right. 11:16. All right. It's overtime. We still have some people that are engaged, and I will stay as long as it takes to answer these questions. So hang in there. Let's see. If I develop trust, okay. If we don't subscribe to the client care program, okay, that's answered that one. I am single. I have a will and a trust, as well as a special needs trust for one child. Good for you. The only thing in the standard trust right now is my house. All my accounts have POD designations listing my non-special needs child as beneficiary. My will states how much is to be passed to the special needs trust, with everything else going to my other child. Do I need to do anything different? Yes, probably. If the only thing, I mean, what's going to pass through your will? If you've got POD designations on all the accounts, there's nothing going to pass through your will, and so nothing is going to go to the special needs trust. That's the problem with this. So I would have to look at the specific situation, but it sounds like having a POD on everything to go to your non-special needs child may not be the right way to do that. But I would have to really see those documents and talk to you just to make sure that it does what you want it to do. Is it irrevocable trust the only way to protect assets from nursing home care? No, you can just give the assets directly to your kids. But at that point, you've still got the 5-year look back period. The problem with doing it, there's several problems with giving away assets instead of using an irrevocable trust. Number one, your kids are going to pay way more in capital gains tax when they sell your house than it would cost to set up the trust. No doubt, especially if you bought the house more than 5 years ago. Okay, so the trust gets a step up in basis. The gift during your lifetime does not get a step up in basis. Your kids are going to pay tens of thousands in capital gains tax. Irrevocable trust, instead of giving assets away during your lifetime, also protects them from the creditors or the divorces of the people they might give them to. So if you give your house to your kids and say, now in 5 years I can go on Medicaid and have that pay for my nursing costs. Well, what if your child gets divorced? Now their divorcing spouse is going to have a claim to half of your house that you just gave to your child. Also, God forbid your child dies. Now your house is going to be transferred from their estate to their kids. Maybe have to pay some expenses or things that they had. What if they go bankrupt? What if they get sued? Now your house gets dragged into this lawsuit. So yes, a trust avoids all those problems. Giving it directly to the people would protect it from you having to spend it on nursing care, but it might not protect it against you losing it, and it certainly would be a problem with capital gains tax. So yes, we recommend irrevocable trust when you're planning for nursing home costs, and we recommend that you do it early because there's a 5-year look back period on those transfers. What's the main difference between revocable and irrevocable trust? Great question. Revocable, you can change at will. Revocable, there's no protection for your assets. So somebody can sue you, you can divorce, etc. All those assets are just like you held them in your own name. There's no protection there. That's a revocable trust. Now, an irrevocable trust is very hard to change. It can protect assets from your creditors or your spouse or nursing home costs, but it's harder to change. And that's the trade-off. Now, it depends on what type of irrevocable trust you have. There's many types, but the general rule is once you put assets into them, it's hard to get them out. We do make it fairly easy to get them out of the irrevocable trust that we do for Medicaid planning for long-term care costs, nursing home costs, by allowing the trustees to get stuff out the back door, give it back to you. All right, let's see. What happens with or how is an irrevocable trust handled post-death? Do the assets get dispersed and the trust is dissolved, or question mark? Yes, just like a revocable trust, except one nice thing about irrevocable trust is they don't have to pay any of your debts. So a revocable trust is liable to pay, your funeral bill and maybe your credit cards and whatever other debts that you have. But if you put assets into an irrevocable trust, they go directly to your beneficiaries without stopping at the creditor's stand and paying the debts. All right. Great questions. Okay. Thanks for the presentation. You're welcome. I think that's it. All right, I do appreciate everybody that came today, and thank you for your questions. I hope you learned something, and I would love to meet with you if you need to talk about a Wisconsin estate plan for you or your parents or another loved one. Give us a call, 608-268-5751, or our 414 number is 414-285-1082. We have we're in Brookfield, Madison, and Oregon, Wisconsin. We practice throughout the state, and with the new rules, we can do wills and trusts and powers of attorney anywhere that you are, as long as you have a camera on your laptop or some sort of a device. I guess a smartphone would work, tablet, that kind of thing. We can do estate planning for you now with the new rules. All right. That's that. Please give us a call, email me. I'd love to hear from any of you. Take care. Have a happy Easter, and God bless. Now I have to figure out how to end the session.